Professional ethics. Historical perspective and regulation of legal profession. Historical perspective. Before British period. In India, the legal profession originated during the British rule. There is no evidence of the existence of legal profession before that. During the Hindu rule and Mughal dynasty period, the administration of justice was in the hands of the king and the king's court was treated as the highest court of the country. There is no appeal against the order of the king. Persons disobeyed the king's order was charged with sedition. During that period the king was respected as the representative of God who was sent by the God to render justice to the people. In the king's court the plaintiff has to represent his case personally and thereafter the king will hear the other side. To assist and advise and the king in the administration of justice there was a council of ministers and a group of educationalists. During Britishers period, the East India Company, which started its business in India, during 16th century slowly started capturing important cities in India and they started administering those areas under their control. They have created company courts and those courts were headed by persons having no legal knowledge. And persons having no legal knowledge were allowed to practice in the court. The first time in India, the legal profession was recognized and regulated by the Charter Act of 1774. This act has permitted the English lawyers to practice in the Supreme Court of Calcutta. Later on in 1801, the English lawyers were allowed to practice in the Madras Supreme Court and in the year 1823 they were allowed to practice in the Bombay Supreme Court, but Indian lawyers were not allowed to practice in those courts. In 1826 these three Supreme Courts were abolished and in that place High Courts were created. In 1865, the Special Rights Act has conferred the right to the Madras, Bombay, and Calcutta High Courts to frame rules for the recognition of advocates and for preparing the advocate's roll. In 1879, the Legal Practitioners Act has conferred the similar power to the other High Court were allowed to practice in that High Court. As per this act persons studied law in England were called as advocates and persons studied law in India were called as vakils. The vakils were not allowed to practice before the High Courts. In 1923 an Advocates Committee was constituted under the leadership of Sir Edward to study the legal profession and to make suitable recommendations to improve the legal profession. This committee has recommended for the creation of bar councils in each High Court and allowing the vakils to practice before the High Court. Accepting the recommendation Bar Council Act was passed in 1926. This act was paved the way for the creation of bar councils in each High Courts. But the Bar Council was not empowered to enroll advocates, that power was retained with the High Courts. The function of the Bar Council was only advisory and the rules and regulations made by the Bar Council shall be brought into force only after the concurrence from the High Court. After independence. After independence in the year 1951 an Advocates Committee was constituted under the chairmanship of Justice C.R. Das to study the problems in the legal profession and make suitable suggestions to remedy such problems. This committee has made the following recommendations. All India level, one Bar Council namely Bar Council of India and in each state Bar Council should be created. Power to enroll advocates and disciplinary power against the advocates should be entrusted with the Bar Council. Advocates should be allowed to practice throughout India without any discrimination. The Fifth Law Commission also scrutinized these recommendations and recommended for the implementation of these recommendations. Accepting these recommendations, the central government passed the Advocates Act in the year 1961. Act has suitable provision for creation of bar councils. The bar councils are entrusted with the power of regulating the legal profession. Regulation of legal profession. The central government passed the Advocates Act in the year 1961. Act has suitable provision for creation of bar councils. The bar councils are entrusted with the power of regulating the legal profession. Salient Features of Advocates Act 1961. The Advocates Act was passed by the Parliament in the year 1961. Following are some of the important salient features. The Act has consolidated all the existing law on legal profession. The Act has made provision for the creation of Bar Council of India at the central level and state bar councils in each state. The Act has made the provision for the preparation of common roll of advocates throughout India. It empowers advocates whose name is in the common roll to practice in all the courts in India. The difference between the advocates and vakil is abolished and all those who practice law is called as advocates. Provisions are made to confer the status as senior advocate for those advocates who possess extraordinary knowledge in the field of law. It has conferred autonomous status to the bar councils. Admission, enrollment, and rights of advocate, bar councils. Admission and enrollment of advocate. Qualification for enrollment. Qualification prescribed for enrollment. Section 24 of the Advocates Act prescribes the following qualifications for a person to enroll as an advocate. He must be a citizen of India. He must have completed 21 years of age. He must have passed 3 years law course, regular study from the university after graduation, or 5 years integrated law course after 10+2. If the law degree is from any foreign university, then it must be a recognized degree, for the Advocates Act by the Bar Council of India. He should pay an enrollment fee as may be prescribed by the State Bar Council. He must fulfill such other conditions as may be prescribed by the State Bar Council for the purpose of enrollment. No upper age limit for enrollment is fixed in the Advocates Act. So, after 21 years at any age one can enroll as an advocate. Disqualification for enrollment. The following persons are disqualified to enroll as an advocate, Section 24A. A person convicted for an offense involving moral turpitude. A person convicted for an offense under Untouchability, Offences, Act, 1955. A person dismissed or removed from government service on any charge involving moral turpitude. The disqualification ceases to have effect after the period of 2 years of his release from jail or dismissal from service. There is no disqualification for a person found guilty in the above said cases and who has been given benefit under the provisions of the Probation of Offenders Act, 1958. If an application for the enrollment is refused on any one of the above grounds of disqualification, the State Bar Council has intimate that facts stating the name, address, reasons for refusal to all other State Bar Councils, thereby he shall be prevented from applying to the other State Bar Councils for enrollment. A person cannot be permitted to carry on other profession along with legal profession. So, a person with a law degree is carrying on the other profession is disqualified to enroll as an advocate. See Hani Raj L. Hulani v. Bar Council of Maharashtra at p. 66. A full-time salaried law officer is not entitled to enroll as an advocate. Satish Kumar Sharma v. Bar Council of Himachal Pradesh, Air 2001 SC 509. Rights of advocate. Right to practice of law in India. Chapter 4 of the Advocate Act 1961, deals with the core aspect of right to practice the profession of law in India. The right to practice law is a fundamental right protected under Article 19, 1, g, of the Constitution subject to reasonable restrictions. Meaning of right to practice of law. Right means permission to do or not to do something. Practice means repeating or habitual. A person habitually representing the parties in the court would amount to practicing the profession of law. Thus, right to practice of law means permission practice the law profession. Scope of right to practice of law. Appearing in the courts. Consulted by the clients. Give his legal opinion whenever sought for. Draft instruments, pleadings, affidavits or any other documents. Participate in any conference involving legal discussions. He can work in any office or firm as a legal officer. He can appear for clients before an arbitrator/s. Right to practice in all courts, tribunals and authorities. Section 30 of Advocate Act 1961 grants monopoly power to an advocate whose name is entered in state roll the right to practice throughout the territories to which this act extends. In all courts including the Supreme Court. Before any tribunal or person legally authorized to take evidence and before any other authority or person before whom such advocate is by or under any law for the time being in force entitled to practice. In Gazette notification dated June 9, 2011, the central government brought into force the provision of Section 30. Right of advocate to simultaneously practice two professions. According to Bar Council of India Rules, 1975, Section 7 of the rules dealt with restrictions of other employments, and Rule 49 provided that a person who is otherwise qualified to be admitted as an advocate but either in full or part-time service or employment or is engaged in any trade, business, or profession, shall not be admitted as an advocate. Provided, however, that this rule shall not apply to any person who is in part-time service as a professor, lecturer, or teacher in law. According to Advocates' Right to Take Up Law Teaching, Rules, 1979, Rule 3. A practicing advocate can teach in university under University Grant Commission Act 1956, subject to teaching hours not exceeding 3 hours a day. Bar Councils. The Advocates Act 1961 confers autonomous status to the Bar Councils. State Bar Council. Constitution. Section 3 of the Advocates Act empowers for the creation of state bar councils for every state. Number of members of the Bar Council varies from state to state, depending upon the number of advocates on the state roll. 1. If the number of advocates in the state roll is less than 5,000 and the number of Bar Council members are 15. 2. If the number of advocates are 5,000 to 10,000 and the number of Bar Council members are 20. 3. If the number of advocates are more than 10,000 and the number of Bar Council members are 25. State Bar Council members are elected by the advocates whose names are there in the state roll by a single transferable vote. The members hold office for a period of 5 years. The Advocate General of the concerned state is an ex officio member of the State Bar Council. So long as he is holding the office as Advocate General, he can act as the member of the Bar Council. Powers. The State Bar Council is empowered with the following powers. It is body corporate. It is a legal body having the autonomous status. It has a common seal and perpetual succession. It can do the following things in its own name: buying and selling properties, entering into agreements, filing cases. It can constitute executive committee, etc. It can frame rules and regulations relating to day-to-day administration. Functions. Advocates Act empowers the State Bar Council to do the following functions: enroll the qualified persons as advocates. Prepare the advocate's roll. Take disciplinary action for professional misconduct. Protect the rights and privileges of the advocates. Encourage law reforms. For this purpose it organize seminars, talks, and publish journals. Constitute executive committee, enrollment committee, disciplinary committee, legal aid committee, etc. Manage the funds of the Bar Council. Conduct the election for electing the members of the State Bar Council. Prepare legal aid programmers and allot separate funds for the implementation of such schemes. Prepare schemes for helping the poor advocates and allot separate funds for the implementation of such schemes. Grant recognition to the law colleges. Do all other acts which are necessary for the effective implementation of the above said functions. Bar Council of India. Constitution. The following persons are the members of the Bar Council of India. 1 member from each state bar councils. He will be elected by the members of the respective state bar councils. Attorney General of India ex officio member. Solicitor General of India ex officio member. Ex officio members will continue as members so long as they hold the offices of Attorney General and Solicitor General posts. The other members will continue as members so long they are continuing as members of the State Bar Council. Powers. Bar Council of India is empowered with the following powers. It is a body corporate. It is legal persons having the autonomous status. It has a common seal and perpetual succession. It can do the following things in its own name: buying and selling properties, entering into agreements, filing cases, etc. Transfer the name of the advocate from one state role to another state role on his application. It can constitute executive committee, disciplinary committee, legal aid committee, etc. To hear and decide appeal, review, and revision against the orders of the Disciplinary Committee of the State Bar Council. Frame rules relating to day-to-day administration. Functions or rights and duties of Bar Council of India. Section 7 of the Advocates Act empowers the Bar Council of India to perform functions which can be classified as rights and duties. Rights of Bar Council of India. Right to exercise general supervision and control over State Bar Council. Right to recognize university whose degree in law shall be a qualification for enrollment as an advocate, and for that purpose to visit and inspect universities or cause the State Bar Councils to visit and inspect universities and issue directions in this behalf. Right to recognize on a reciprocal basis foreign qualification in law obtained outside India for the purpose of admission as an advocate. Right to constitute on or more funds in the prescribed manner for the purpose of giving financial assistance to organize welfare schemes for indigent, disabled or other advocates. Right to receive any grants, donations, gifts, or benefactions for all or any of specific purpose. Right to lay down procedure to be followed by its disciplinary committee and the disciplinary committee of each State Bar Council. Right to deal with and dispose of any matter arising under this Advocates Act 1961, which may be referred to it by a State Bar Council. Right to establish law libraries. Duties of Bar Council of India. Duty to lay down standards of professional conduct and etiquette for advocates. Duty to safeguard the rights, privileges, and interests of advocates. Duty to promote and support law reform. Duty to promote legal education and to lay down standards of such education in consultation with the universities in India imparting such education and the State Bar Councils. Duty to conduct seminars and organize talks on legal topics by eminent jurists and publish journals and papers of legal interest. Duty to organize legal aid to the poor in the prescribed manner. Duty to manage and invest the funds of the Bar Council. Duty to provide for the election of its members. Duty to perform all other functions conferred on it by or under this Advocates Act 1961. Nature and characteristics of ethics of legal profession. Meaning of professional ethics. The word ethics derived from the Greek word ethos. It means the habitual mode of conduct. Professional ethics means a conduct written or unwritten which prescribes the duties of a profession, legal profession. The legal profession and the judiciary as a whole in all countries have been honored as the pure fountain of justice and enjoys high esteem of respect. In order to maintain the respect, lawyers have to follow certain ethical regulations. Ethics of legal profession. Section 49, I.C. of the Advocates Act, 1961 empowers the Bar Council of India to make rules prescribing the standards of professional conduct and etiquette to be observed by the advocates. The rules made by the Bar Council shall come into effect only when it is approved by the Chief Justice of India. In exercise of this rule-making power, the Bar Council of India has made several rules prescribing the standards of professional conduct and etiquette for the advocates. These rules specifies the duties of an advocate to the court, client, opponent, and colleagues, etc. These rules are broadly called as professional ethics. Legal profession. Meaning of legal profession. Profession. Scruton LJ defines profession as: profession is the present use of language involves the idea of an occupation requiring either purely intellectual skill or manual skill controlled. He recognizes professional functions as church, medicine, and law. Indian Supreme Court distinguishes professional as: professional men should possess a certain minimum degree of competence and that they should exercise reasonable care in the discharge of their duties. Contempt of court. Object of the Act. The main object of the Contempt of Court Act is to protect the dignity and decorum of the court and to uphold the majesty of law. The object is not to protect the judges from criticism. By providing punishment for contempt of the court, the ability to deliver fearless and impartial justice is strengthened. Contempt of court. Object of the Act. The main object of the Contempt of Court Act is to protect the dignity and decorum of the court and to uphold the majesty of law. The object is not to protect the judges from criticism. By providing punishment for contempt of the court, the ability to deliver fearless and impartial justice is strengthened. Definition. The definition given in the Act for the term contempt of court is not exhaustive. It is difficult to define it by words, because the scope of contempt of court is very wide. Contempt means any disrespect to the authority of law, disobedience of the order of the court, disturbance to the proceedings of the court. Types. Following are the types of contempt: civil contempt and criminal contempt. Civil contempt. Section 2(b) defines the term civil contempt. It means willful disobedience to any judgment, decree, direction, order, writ or other process of a court, or willful breach of an undertaking given to a court. For taking action for civil contempt on the ground of willful disobedience of court order, it should be established that the court which has passed the order has jurisdiction to pass such order. Disobedience of an order passed without jurisdiction is not a contempt, must prove that the court has no jurisdiction. A willful breach of an unconditional undertaking given orally or in writing, either in person or through his advocate, will be treated as civil contempt. When undertakings are given orally, the court shall record it in the proceedings. Breach of a compromise entered in the court cannot be treated as civil contempt. The remedy in such cases is only a civil suit for specific performance of the promise. Punishment. Section 12 prescribes the punishment for contempt. Court may award any one of the following punishments: simple imprisonment for a term which may extend to 6 months. Fine which may extend to Rs.2000/. Both the punishment, i.e., imprisonment and fine together. Criminal contempt. Section 2C defines the term criminal contempt. It means publication of any matter, by words, spoken or written, or by signs or by visible representation or otherwise. Doing of any other act which scandalizes or tend to scandalize, or lowers, or tends to lower the authority of any court, or prejudices or interferes or tends to interfere with the due course of judicial proceeding, or interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice. Publication means publishing something orally or in writing through newspaper, pamphlets, radio, television, or cinema. Conversation between two persons cannot be treated as publication. To decide criminal contempt, the absence of criminal intention on the part of the person who has published the matter containing criminal contempt or done the act of contempt will not be taken into account. In EMS Nambatharabad vs. T.N. Mombiar, Air 1970 SC 2015, the then Chief Minister of Kerala, Mr. Nambatharabad, in a press meet expressed the following about judiciary. Judiciary is responsible for the suppression of people. Judges are favoring some class of people and working against the other classes. Judiciary is acting against the interest of working class and the agriculturist. Judiciary is helping the oppressor group. The Supreme Court held that the act of Mr. Namboothirabad amounts to criminal contempt. Making complaint against a judge about his misconduct with sufficient evidence to the higher authorities is not a contempt. But, the same complaint is published in any manner, then it amounts to contempt. Preventing the court amin from executing the court order, threatening an advocate not to appear in a particular case, threatening the witness, preventing the witnesses from attending the courts, preventing the commissioner from performing his duties are treated as criminal contempt. C.D.C. Saxena v. Chief Justice of India. Punishment for contempt.
Section 12 prescribes the punishment for contempt of court. Punishment is same for the civil as well as the criminal contempt. If the charge of contempt of court is proved, the court shall award any one of the following punishments. Simple imprisonment for a term which may extend to 6 months. Fine which may extend to Rs 2000-. Both the punishments, i.e., imprisonment and fine together. According to Section 12(2), for contempt of court any one of the above mentioned punishment alone can be given and not any other. Both the punishments.
Punishment for contempt.
Section 12 prescribes the punishment for contempt of court. Punishment is same for the civil.
Section 12 prescribes the punishment for contempt of court. Punishment is same for the civil as well as the criminal contempt. If the charge of contempt of court is proved, the court shall award any one of the following punishments. Simple imprisonment for a term which may extend to 6 months. Fine which may extend to Rs 2000-. Both the punishments, i.e., imprisonment and fine together. According to Section 12(2), for contempt of court any one of the above-mentioned punishment alone can be given and not any other punishment alone can be given and not any other punishment. But, in Delhi Judicial Services Association v. State of Gujarat, AIR 1991 SC 2176, the Supreme Court held punishment not mentioned in S.12 can also be given for contempt of court. In Re Vinay Chandra Mishra, AIR 1995 SC 2348, the Supreme Court held that for contempt of court committed by an advocate, he shall be suspended from practice for a fixed period or he shall be permanently restrained from practice. The Supreme Court Bar Association has filed a review petition against this order, in which the Supreme Court held that for contempt of court the court cannot cancel the advocate's right to practice, but he shall be suspended from practice for a fixed period. For the civil contempt, normally fine alone will be imposed. If the court thinks that fine alone is not a sufficient punishment, then he shall be put in the civil prison instead of ordinary imprisonment. If the contempt of court is committed by a company in collusion of the directors, secretary and other managerial staff, then shall be detained in the civil prison. If the contempt is committed by a firm, then the punishment shall be enforced against the partners of the firm.
Defenses against contempt. Defenses in criminal contempt. Section 327 deals with the defenses available in criminal contempt. They are as follows. Innocent publication, Section 3. A person shall not be guilty of contempt of court if he had made any innocent publication of any matter pending before a court without knowing that the matter is pending a court. The person charged with contempt must prove that publication is made without knowing that the matter is pending in the court. Publication relating to a decided case, Section 3, 2. Publication about the decided case is not a contempt since the case is already decided by the court. The publication is not going to interfere with the disposal of the case. That is why it is not treated as contempt. Distribution of publication without knowing that it contains contempt of court matter, Section 3, 3. If a person distributes an publication without knowing that it contains contempt of court matter, then it cannot be treated as contempt. If the publication does not contain the name and address of the author, publisher, and printer, then this defense cannot be used by the person distributing such publications. Fair and accurate reporting of judicial proceedings, Section 4. Fair and accurate reporting of judicial proceedings is not a contempt. This is because we are following the principle of openness in the matter of administration of justice. The following reporting of judicial proceedings, though it is fair and accurate, it will be treated as contempt of court. Reporting of the proceedings against any law which is in force. Reporting of the proceedings when the court has prohibited the reporting in the interest of the general public. Reporting of the proceedings conducted in the judge's chamber in the interest of defense of public order. Reporting of information relating to secret process, discovery, or invention which is an issue in the case. Fair criticism of judicial act, S.5. A proper and fair comment on a decision is not a contempt of court. Criticism is permitted to the extent where it does not interfere with the administration of justice. So, it is open to anyone to express fair, reasonable, and legitimate criticism of a judicial decision. Bona fide complaint against the presiding officers of a subordinate court, Section 6. A bona fide complaint made in good faith against the presiding officer of a subordinate court to the higher authorities, who have control over such subordinate court, is not a contempt. No substantial interference with the administration of justice. It means an act which is technically a contempt, but such act does not substantially interfere with the administration of justice. For such acts no punishment is awarded. Defenses in the civil contempt. Following are some of the important defenses available to a person charged with civil contempt. Disobedience of the order is not willful. If the disobedience of the order is accidental or which is not willful, then it's a good defense in a civil contempt proceedings. The order passed without jurisdiction. If the order passed by the court is without jurisdiction, then the disobedience or violation of such order cannot be treated as contempt of court. An order passed without jurisdiction is void, hence it won't bind any person. The person charged with contempt must prove that the court has no jurisdiction to pass such order. Order disobeyed is vague or ambiguous. An order is treated as vague if it is not clear, specific, and complete. For violation of such order, contempt proceedings cannot be taken. Order involves more than one reasonable interpretation. If the order of the court involves more than reasonable interpretation, and one interpretation is adopted by the party and acted in accordance with such interpretation, then he cannot be held liable for contempt of court for not following the order interpretation. Compliance with the order is impossible. Impossibility means that the implementation of the order is practically not possible. Impossible is different from mere difficulty. Mere difficulty is not a defense. The person charged with contempt must prove the impossibility of compliance with the order. In Amar Singh vs. K. P. Gethakrishnan, 1993 ISCR 465, the court has passed on order to give some benefits to the retired employees. This order was not implemented. In the contempt proceeding, it was argued that the implementation of the order involves huge expenditure, hence compliance with the order is impossible. The court has not accepted this defense. No knowledge of the order. A person cannot be held liable for civil contempt if he has no knowledge about the order. If he has knowledge about the order, though it is not officially communicated to him, then he cannot put this defense for violation of the order. Constitutional validity of contempt law. Article 129 of the Constitution of India says that the Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. According to Article 215 of the Constitution of India, every High Court shall be court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Parliament and the state legislature both have power to make laws with respect to any of the subject enumerated in List 3, concurrent list, of the 7th schedule of the Constitution. The Parliament has exclusive power to make laws with respect to any of the matters or subjects enumerated in List I, Union List, of the 7th of the Constitution. The state legislature has exclusive power to make laws with respect of any of the matter or subjects enumerated in List 2, State List, of the 7th scheduled of the Constitution. Entry 77 of the list is as follows. Constitution, organization, jurisdiction, and powers of the Supreme Court, including contempt for such a court, and the fees taken therein, persons entitled to practice before the Supreme Court. Entry 15 of List 2 is as follows: contempt of court but not including contempt of Supreme Court. The legislature is fully competent to legislate with respect to contempt of court, subject only to the qualification that the legislature cannot take away the power of the Supreme Court or the High Court to punish for contempt or vest that power in some other court. Article 142, 2, of the Constitution of India states that the Supreme Court shall have all and every power to make any order for the purpose of securing the attendance of any person, the discovery or production of any document, or the investigation or punishment of any contempt of itself. According to Article 372 of Constitution of India, all the laws in force in the territory of India immediately before the commencement of this Constitution shall continue in force therein until altered or repealed or amended by a competent legislature or other competent authority. That is why Section 22 of the Contempt of Courts Act 1971, it makes it clear that the provision of this Act shall be in addition to and not in derogation of the provision of any other law relating to contempt of courts. The Contempt of Courts Act is not violation of guarantee of equality, and Article 14 as the classification of a founded on the intelligible differentia which distinguish persons or things that are grouped together from other left out of the group, and the differentia has a rational relation to the object thought to be achieved by the statute in question is reasonable. As the existing law relating to contempt of court imposes reasonable restrictions within the meaning of Article 19, 2, and therefore, it is not violated. Constitutional validity of contempt law. Article 129 of the Constitution of India says that the Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt. Constitutional validity of contempt law. Article 120. Constitutional validity of contempt law. Article 129 of the Constitution of India says that, the Supreme Court shall be a court of record, and shall have all the powers of such a court, including the power to punish for contempt of itself. According to Article 215 of the Constitution of India, every High Court shall be court of record, and shall I have all the powers of such a court, including the power to punish for contempt of itself. Parliament and the state legislature, both have power to make laws, with respect to any of the subject, enumerated in List 3, concurrent list, of the 7th Schedule of the Constitution. The Parliament has exclusive power to make laws, with respect to any of the matters, or subjects enumerated in List I, Union List, of the 7th of the Constitution. The state legislature has exclusive power, to make laws with respect of any of the matter, or subjects enumerated in List 2, State List, of the 7th Schedule of the Constitution. Entry 77 of the list is as follows. Constitution, organization, jurisdiction, and powers of the Supreme Court, including contempt for such a court, and the fees taken therein, persons entitled to practice before the Supreme Court. Entry 15 of List 2 is as follows: contempt of court but not including contempt of Supreme Court. The legislature is fully competent to legislate with respect to competent of court, subject only to the qualification that the legislature cannot take away the power of the Supreme Court or the High Court to punish for contempt or vest that power in some other court. Article 142(2) of the Constitution of India states that, the Supreme Court shall have all and every power, to make any order for the purpose of securing the attendance of any person, the discovery or production of any document, or the investigation or punishment of any contempt of itself. According to Article 372 of Constitution of India, all the laws in force in the territory of India, immediately before the commencement of this Constitution, shall continue in force therein until altered or repealed or amended by a competent legislature, or other competent authority. That is why Section 22 of the Contempt of Courts Act 1971, it makes it clear that the provision of this Act shall be in addition to and not in derogation of the provision of any other law relating to contempt of courts. As the existing law, relating to contempt of court imposes reasonable restrictions, within the meaning of Article 19(2), and therefore, it is not violative of the fundamental right to freedom of speech and expression, guaranteed by Article 19(1)(2) of the Constitution. The Contempt of Courts Act is not violation of guarantee of equality and Article 14, as the classification of a founded on the intelligible differentia, which distinguish persons or things that are grouped together, from other left out of the group, and the differentia has a rational relation, to the object thought to be achieved, by the statute in question is reasonable. According to Clause 10 of the Article 366, the existing law means any law, ordinance, order, by law, rule, or regulation passed or made before the commencement of this Constitution by a legislature, authority or person having power to make such a law, ordinance, by law, rule or regulation. The contempt of law is not violative of Article 21, which provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law, as the existing procedure for contempt proceedings have statutory sanction. Section 10 of the Contempt Act 1971 makes it clear that every High Court shall have and exercise the same jurisdiction, powers and authority in accordance with the same procedure and practice in respect of contempt of courts subordinate to it as it has an exercise in respect of contempt of itself. Beside this, Article 225 of the Constitution of India makes provision for its continuity. Hence, on the above grounds, it can be concluded that the Contempt of Court at 1971 is not violative of any provision of the Constitution, and it is constitutionally valid. Contempt by lawyers, judges, state, and corporate bodies. Contempt by lawyers. The court has power to punish every person, body, or authority found guilty of contempt of court. The contempt jurisdiction is very wide. The lawyer has to discharge certain duties towards the court. But sometimes because of the nature of duties, the lawyers and judges may get into heated dialogue, which may result in contempt of court. Contempt by lawyers is the most pertinent problem before the courts these days. There are several instances of misconduct, which have been taken as contempt of court. For example, using insulting language against the judge, making scandalous allegations against a judge, suppressing the facts to obtain favorable order, allegation of partiality and unfairness against the judge, etc. An advocate who advises his clients to disobey the court is also held liable for contempt courts. In bar council election, attacking judiciary is also taken at contempt of court if a counsel advocate refuses to answer the question of the court, is also liable for the contempt of court. Contempt by lawyers, cases. In Re Ajay Kumar Pandya, AIR 1998 S.C.3299, the Supreme Court has held that an advocate using intemperate language and casting unwarranted aspersion, false report, on various judicial officers, is a quality of gross contempt of court, for not getting expected results. Court awarded punishment of sentence to 4 months simple imprisonment, and fine 1,000 rupees / Supreme Court in this case warned that, only because a lawyers appear as a party in person, he does not get a license to submit contempt of court, by intimidating the judges or scandalizing the court. An advocate can use language, either in pleading or during argument, which is either intemperate or unparliamentary, and which has tendency to interfere in the administration of justice, and undermine the dignity of the court. In another case, Re Vijay Chandra Mishra AIR, 1995, SC 2348. Supreme Court held that to resent, to show anger, the question asked by the judge, to be disrespectful to him, to question his authority, to ask question, to shout at him, to threaten him with transfer and impeachment, to use insulting language, to abuse him, to dictate order. Such acts of advocate tends to prevent court from performing its duty to administer the justice and hence, are instances of contempt of court. Narayan Das vs. Government of Madhya Pradesh Year 1974 SC 1252. It has been held that, if a wrong or misleading statement is deliberately and willfully made by the party to a litigation with a view to obtain a favorable order, it would prejudice or interfere with the due course of the judicial proceedings, and thus amount to contempt. Bombay vs. Srimati Anadi Ramand Uttanwala, 1987, CRLJ 1038. An advocate was personally engaged in earlier litigation involving a particular property, and which has resulted in an eviction order against the client of the advocate, who suppressed these facts in the pleading in subsequent proceeding, brought by the wife of his client, in respect of the same property, and obtained an interim injunction, restraining the municipal corporation from interfering with the possession of the wife. Bombay High Court held the advocate guilty of contempt. Justice Savant of the Bombay High Court delivering the judgment observed that, the contempt by suppressing the facts, had fraudulently obtained from the court's favorable orders, and had thus prejudiced, and interfered with the due course of the judicial proceeding, and had also obstructed the administration of justice. That a false statement, made to the court, with a view to obtain a favorable order, amounts to contempt of the court. Contempt by judges. The offense of contempt of courts can be committed by not only an ordinary person, but it can be committed by a judicial office. Such contempt could be by virtue of any act done which lowers the dignity of court or obstructs the judicial process. Section 6 empowers a person to make a complaint against a presiding officer of a subordinate court in case of any contempt liability. Section 16 says that a judge, magistrate, or any other person acting judicially, shall be liable for contempt of his own court, or of any other court, in the same manner, as any other individual is liable, and the provisions of the same statute shall equally apply. Contempt by state. State is also not allowed to contempt of law. If an decision is passed and it is found that state deliberately disobeyed the order, then responsible officer for execution will be charged for contempt of court. Defenses. Officer was not aware about order. Court not competent. Ambiguity or vague order. Double meaning order. Order impossible to execute. Disobedience was not willful. Contempt by corporate bodies. In case of corporate bodies, any agent or officer who works for corporate, and deliberately disobey orders of courts, will be responsible for contempt of court. Defenses. Officer was not aware of order. Officer was not aware about disobedience. Remedies for contempt of court. Apology. Appeal. No remedy of review. Strike by the lawyers. Whether boycott of court or strike by lawyers amount to contempt of court is still a controversial issue. Thorani Mohan of Pleaders, AIR 1923, Cal 212. In this old decided case, Calcutta High Court held that the Bombay Council has no power to call strike of lawyers and such call amount to contempt of court. It was observed that boycotting the court, the advocate violates his duties not only towards the client but also towards the court. See also duties of an advocate towards a client. Many great jurists India writing, expressed their view that there is no justification for the lawyers to boycott the court or to participate. It is taken as professional misconduct. Extent of professionalization of legal profession. Code of Ethics for Lawyers. The word ethics derived from the Greek word ethos. It means the habitual mode of conduct. Professional ethics means a conduct written or unwritten which prescribes the duties of a profession, legal profession. The legal profession and the judiciary as a whole in all countries have been honored as the pure fountain of justice and enjoys high esteem of respect. In order to maintain the respect, lawyers have to follow certain ethical regulations. Section 49, I.C. of the Advocates Act. Section 49, I.C. of the Advocates Act, 1961 empowers the Bar Council of India to make rules prescribing the standards of professional conduct and etiquette to be observed by the advocates. The rules made by the Bar Council shall come into effect only when it is approved by the Chief Justice of India. In exercise of this rule-making power, the Bar Council of India has made several rules prescribing the standards of professional conduct and etiquette for the advocates. These rules specify the duties of an advocate to the court, client, opponent, and colleagues, etc. These rules are broadly called as professional ethics. 7 Lamps of Advocacy. Justice Abbott Perry qualifies the following qualities as 7 lamps of advocacy. They are: honesty, courage, industry, wit, eloquence, judgment and fellowship. Honesty. Honesty is the most important quality that an advocate should possess. His thoughts, words, and deeds should have sincere correlation to each other with genuineness. An advocate should be dependable, reliable to everyone who seeks his advice and services. The uprightness, integrity, and honesty of the advocate will increase his reputations and respect in the society. Courage. It is the duty of an advocate to fearlessly uphold the interest of his client by all fair means without fear of any unpleasant consequences to himself or any other person. It is the knowledge and the skill of the advocate that gives him the necessary courage and confidence to present the case fearlessly and to uphold the interest of the client. The knowledge and the skill can be acquired and developed by mastery of facts, mastery of laws, mastery in drafting and presentations of convincing arguments. Industry. It means hard work. Hard work is absolutely necessary for an advocate. His knowledge of law should be up to date. He shall never be ignorant of the current law in force. He shall get acquainted with the latest law by systematic study. If one ignores the law will also ignore him. That is why it is said that law is the jealous mistress. Wit. Judges and lawyers have to deal with a variety of serious and important matters affecting life and liberty of the people. So constant clash between them is common. Anxiety for a favorable verdict on the part of the lawyers, and perpetual worry for the pursuit of the truth on the part of the judges generate strain and tension. Occasional wit and humor, provoking a smile or laughter will help them to ease the tension, and refresh themselves to sharpen their brain for the effective discharges of the duties. Eloquence. Eloquence means the fluency, force, and style of using the language. Strong vocabulary is one of the powerful weapons which an advocate should possess. Words are his keys of thoughts. Strong vocabulary gives him assurance, build his self-confidence and build his personality. Words must be employed with eloquence. The art of persuasive and impressive speaking will give the desired result in his favor. Judgment. It means the ability to come to a sensible conclusion and make wise decisions at the relevant time in the proper way. It is on the basis of these conclusions he should employ the necessary facts and the techniques in the case which he is engaged. An advocate must always anticipate all the possible moves of the other side to take necessary actions. Fellowship. In legal profession, one advocate fights with another advocate for justice before the learned judge. Controversies and contradictions in case shall never affect the fellowship. The advocates should refer the opposite party's advocate as learned friend and the judge should be referred as learned judge. In order to maintain the fellowship, the Bar Council of India has laid down certain rules to be observed as the duty to colleagues. Panchsheel of the Bar. Panchsheel refers to the following 5 qualities. They are: honesty, industry, justice, service and philosophy. Honesty. Advocate should be honest in profession. Industry. Advocate should work hard. Justice. An advocate is as an officer of the High Court. He should help the judge in finding out the truth in the dispute and help him to arrive the right decision. For this purpose, he shall submit the proper position of the law, facts, and evidence related to the case. An advocate has to protect the interest of the client, but at the same time he must realize that he is not the mere mouthpiece of the client. Therefore, he shall never resort to unfair the practices. His efforts should be always to advance the cause of the justice. Service. Legal profession mainly concerned with the promotion of administration of justice and the establishment of the welfare society. Therefore, lawyers shall be willing to protect the right of the oppressed and the poor. They shall render their service to the general public without any discrimination. Philosophy. Lawyers should have some philosophical outlook. An advocate has to deal with the variety of disputes both favorable and unfavorable to his client. So, he should have the required mental fitness to adjust and accommodate with the changes. It is therefore necessary that lawyers should be guided by some philosophical principles suitable to the profession. 10 Commandments of Advocates. The various duties of an advocate, like duties to the client, duties to the court, duties to the colleagues and duties to the public, shall be put into the following 10 rules, popularly known as the 10 Commandments of Advocates. Protection of the interest of the client. An advocate must be loyal to the interests of the client and fight for his cause without the fear of any unpleasant consequence to him or any other person. See duty to the client. Proper estimation of the value of the legal advice. An advocate shall not overestimate or underestimate the value of his advice. He must always give proper legal advice to the client. Honest and respect. He must be always honest and respectful to the court. Preparation of the case. He must prepare the case thoroughly before presenting it to the court. Service. Lawyers shall be willing to protect the rights of the oppressed and the poor. Loyalty to law and justice. He must always give advice to enhance loyalty to law and justice. Fellowship. He must be always friendly with the fellow members of the bar and more friendly with the young lawyers and encourage them. Fairness. He must be fair in his dealings with the client, with the court and with the public. Systematic study. He must develop the habit of systematic study of the law and acquainted with the latest developments in law. Prudence and diligence. He must always vigilant and active. He must avoid the easy come and easy go method. Professional misconduct and its control. Professional misconduct. Misconduct means dereliction of duty. Professional misconduct means dereliction of duty relating to legal profession. Under Section 35 of the Advocates Act, an advocate is punishable not only for professional misconduct but also for other misconduct. Other misconduct means a misconduct not directly connected with the legal profession. Professional misconduct arises as a result of serious dereliction of duties to the court, to the client, to the opponent, to the colleagues, to the profession, to the public, etc. Following are some of the instances of professional misconduct. Making false allegation against judicial officers. Deliberately lodging groundless criminal complaint. Making groundless and insulting charges against witness. Refusing to accept a case without justification. Attending court proceedings in drunken state. Attempting to influence judicial officers for favor. Carrying on other trade or business. Committing crimes. Financing litigation. Obtaining client's signature on blank papers. Shouting slogans or holding demonstration in front of the court. Approaching investigative officers for favor during investigation of a case. Writing letter to the presiding officer in connection with the pending case. Tampering with the witness. Suggesting the client to bribe the presiding officer. Moving application before any court or authority before informing that a similar application has been presented before any authority or rejected by any authority. An exclusively retained pleader accepting a case against the client from the opposite party. Failure to appear in the proceedings of a case without any sufficient reason. Retaining the judgment of the trial court with the intention of getting himself engaged in appeal. Presenting the plaint with insufficient court fee stamp, when the client has given money for the court fee. Alleging partiality against presiding officer in open court. Tampering with records and documents. Writing letters to persons for soliciting cases. Reporting no instructions from his client and subsequently appearing for the opposite party in the same suit. Advertising about his profession. Taking advantage of the ignorance and illiteracy of the clients, demanding money from them on false representations that is required for court purposes and misappropriating the same. Misappropriation of decreed amount payable to the client. Giving wrong advice to the client. Taking money from the client for the purpose of giving bribe. Suppression of truth. Changing sides. Indecent cross-examination. Committing contempt of court. False identifications of deponents. Gross negligence involving moral turpitude. Appearing without authority, i.e., on forged vakalat. Failure to attend a trial. Attesting forged affidavit. Abstaining from appearing in court on the ground of strike called by the Bar Association. Misleading the court resulting in erroneous order. Punishment for misconduct. The Disciplinary Committee of the State Bar Council, after hearing the advocate concerned and the Advocate General, comes to the conclusion that the misconduct is proved that it may pass any of the following orders, namely: reprimand the advocate. Suspend the advocate from the practice for such period as it thinks fit. Remove the name of the advocate from the advocate's roll. Punishment may be awarded depending on the gravity of misconduct established against him. The punishment to remove from the advocate's roll is awarded only in the cases where the misconduct is of such nature that the advocate is unworthy of remaining in the profession. Where an advocate is suspended from the practice, he shall not practice in any court or tribunal or any authority or person during the suspended period. Where notice is issued to the Advocate General, he may appear before the Disciplinary Committee in person or through any advocate appearing on his behalf. If the misconduct is not proved beyond reasonable doubt, then the Disciplinary Committee shall dismiss the petition. Remedies against the order of punishment. Appeal to the Bar Council of India, Section 37. Any person aggrieved by the order of the Disciplinary Committee of the State Bar Council, or the Advocate General of the State, may within 60 days from the date of the order may prefer an appeal to the Bar Council of India. The appeal shall be filed in person or through by advocate or by registered post. He must submit 5 copies of appeal memorandum along with the attested copy of the order of the State Bar Council. Such appeal shall be heard by the Disciplinary Committee of the Bar Council of India, and after hearing it may pass any order it deems fit, i.e. it can confirm the order of the State Bar Council, or increase or reduce the punishment, or totally remove the punishment. Appeal to the Supreme Court. Any person aggrieved by an order made by the Disciplinary Committee of the Bar Council of India, or the Attorney General of India, may within 60 days from the date of order prefer an appeal to the Supreme Court. The Supreme Court, after hearing the parties concerned, shall pass any order as it thinks fit. Normally, the Supreme Court will not interfere with the concurrent findings of fact by the Disciplinary Committee of the Bar Council of India and the State Bar Council. If the finding is based on no evidence, then the court will examine it. Stay of the order. For the convenience of filing an appeal against the order of the State Bar Council or the Bar Council of India, the aggrieved party can file an application before the concerned Bar Council which has passed the order to stay the order. Still appeal is filed. If genuine grounds are there, then the concerned Bar Council can stay the order. Similarly, after filing the appeal before the Bar Council of India or before the Supreme Court, the aggrieved party can ask for the stay of the order, still the disposal of the appeal. If the genuine grounds are there, then the Bar Council or Supreme Court shall stay the order, still the disposal of the appeal. Disciplinary Committee of the State Bar Council. Organization. Section 9 of the Advocates Act empowers the state bar councils to constitute one or more disciplinary committees. Each disciplinary committee shall consist of 3 members. 2 shall be selected from the members of the Bar Council and 1 shall be selected from the advocates who are having more than 10 years of standing in profession. Among the 3 members, the senior most in the profession shall act as the chairman of the committee. Powers of Disciplinary Committee of the State Bar Council. Section 42 of the Advocates Act deals with the power of disciplinary committee. It provides that the disciplinary committee of the State Bar Council shall have the same powers same as the civil court under the CPC in respect of the following matters: summoning and enforcing the attendance of any person and examining him on oath, requiring discovery and production of any documents, receiving evidence on affidavit, requiring any public record or copies of any record from any court or office, issuing commissions for the examinations of witness or documents. The disciplinary committee has no right to require the attendance of the following persons: any presiding officer of the court, any officer of the revenue court. A presiding officer of a court shall be summoned to attend the proceedings of the disciplinary committee with permission of the High Court, and an officer of the revenue court shall be summoned with the permission of the state government. All the proceedings before the disciplinary committee of a bar council shall be deemed to a judicial proceeding within the meaning of Section 193 and 228 of I.P.C, and every such disciplinary committee shall be deemed to be a civil court. Inquiry procedure. The main function of the disciplinary committee of the Bar Council is to inquire the complaints of professional misconduct against the advocates, award suitable punishments. In the inquiry, the following procedures prescribe under Section 35 of the Advocates Act should be followed. On perusal of the complaint, if the Bar Council is satisfied that it is a fit case for inquiry, then the complaint shall be referred for inquiry to the disciplinary committee. The disciplinary committee shall fix a date for inquiry and shall send notice to the concerned advocate and the Advocate General of the state. The advocate charged with the professional misconduct shall appear in person or through the lawyer. Similarly, the Advocate General also appear in person or through a lawyer. If the inquiry was not completed within 1 year, then the complaint should be referred from State Bar Council to the Bar Council of India for its disposal. During the pendency of the inquiry, if the term of the disciplinary committee comes to an end, then the successor committee shall continue the inquiry. After the inquiry, due to the lack of majority opinion or otherwise, if the disciplinary committee was unable to take a final decision, then they shall seek the opinion of the chairman of the Bar Council and shall pass the final order following his opinion. Disciplinary Committee of the Bar Council of India. Organization. Bar Council of India can have the disciplinary committee same as State Bar Council. Section 9 of the Advocates Act empowers the Bar Council of India to constitute one or more disciplinary committees. Each disciplinary committee shall consist of 3 members. 2 shall be selected from the members of the Bar Council and 1 shall be selected from the advocates who are having more than 10 years of standing in profession. Among the 3 members, the senior most in the profession shall act as the chairman of the committee. Powers. The Disciplinary Committee of the Bar Council of India shall have the following powers. It shall inquire the charges of the professional misconduct against advocates whose name is there in the roll of any of the State Bar Council. Inquire the complaints in which the Disciplinary Committee of the State Bar Council has not completed the inquiry within 1 year. Hear the appeal against the order of the State Bar Council. Allowing the State Bar Council to review its own order. Bar Council of India Disciplinary Committee is also having powers like a civil court. Inquiry procedure. Bar Council of India as same process as that of the Disciplinary Committee of the Bar Council. Transfer of proceedings from the State Bar Council to the Bar Council of India. If the State Bar Council after verification is satisfied that the charges of professional misconduct is a fit case for inquiry, then it shall refer it to the Disciplinary Committee for the inquiry. The Disciplinary Committee must complete the inquiry proceedings within 1 year from the date of receipt. The main object of putting a time-bound inquiry is speedy disposal of the cases. Due to any reason, if the inquiry was not completed within a year, then the complaint should be transferred to the Bar Council of India for inquiry. The transfer should be made by the suo motu by the State Bar Council, Section 36B. The complaints so transferred shall be inquired by the Disciplinary Committee of the Bar Council of India and pass suitable orders as it thinks fit. There is no time limit for the Bar Council of India to complete the inquiry. Bar bench relations. The court hall where cases are conducted consists of two parts, namely, the place where the judges sit is called as bench. The place where the advocates sit is called as bar. So the term bench refers to the judges and the bar refers to the advocates. Bar-bench relation means the cordial relation between the judges and the advocates. The faith on the judiciary to the general public and the speedy justice mainly depends on the cordial relation between the judges and the advocates. In the administration of justice, the role of advocates are also equally important, just like the judges. Rendering justice is their joint responsibility. Without the help of advocates, it is very difficult for the judges to arrive at a correct decision in a dispute. If good relation exists between the judges and advocates, then delay in rendering justice and high expenses for getting justice can be very much reduced. To strengthen the good relation, both should have some good qualities and mutual responsibilities. Role of the bar to strengthen bar-bench relation. To strengthen the bar-bench relation, the advocates must take the following steps. Respect judges. They should give the due respect to the judges and they must avoid speaking ill of the judges and the judiciary. Help judges in trial. They should help the judges in the trial of the cases by presenting the relevant law in the correct and clear manner. They should never act in such a way to irritate the judges. Appeal instead criticism. If the judges pronounce a wrong order, they should not criticize the judges. They should try to set right the wrong order through appeal. No pressure. For getting favorable order, they should not give pressure or influence the judges. No direct confrontation. If the judge's behavior is irritating and disrespect to the advocates, should not enter into a direct confrontation with the judge. Through the Bar Association, the matter should be discussed with the judge in his chamber and shall request to avoid such misbehavior. Role of the bench to strengthen bar-bench relation. Only when bar-bench relations are strengthened, people will get confidence and fair on the judiciary. To strengthen bar-bench relation, the judges should follow and practice the following. Judicial respect. Just like the advocates are giving respect to the judges should also give to the advocates and the brethren judges. Patient hearing. Judges should hear the case with open and respective mind without any prejudice or bias. They should act only to the interest of justice. They should give sufficient opportunity for the advocates to present the case in full. Impartiality. Judges should act impartially. They should not act in favor of any advocate or a party to the dispute. Avoidance of interruptions. As far as possible, judges must avoid interruptions while the advocate is examining witnesses and arguing the case. Unwarranted interference and adverse comments by the judges may upset the advocates and thereby he may not be able to present the case properly. This may cause the failure of justice. Interference may be limited to the following circumstances. To prevent repetition and waste of time. To check the relevancy. To get clarifications. To express court's view on a point and to promote speedy disposal of the case. Proper interpretation. During the process of administration of justice, often the courts have to interpret the act, rules, orders, and notifications in order to ascertain the actual meaning of the provisions or to remove the ambiguity or inconsistency. In such cases, proper interpretation should be given with the object of rendering complete justice to the parties. Avoidance of unreasonable adjournments. Adjournments are given to afford reasonable opportunity to the parties to present the case. As far as possible, cases shall not be adjourned without reasonable and sufficient grounds. Unreasonable adjournment is the main reason for the mounting arrears of cases, and it causes hardship to the parties. Speedy disposal. Justice delayed is justice denied, hence cases should be disposed of as quickly as possible. When preference is given for disposal of old cases, care should be given to see that new cases should not get into arrears. Avoiding unwarranted comments. Judges should not make any unwarranted comments in the open court about the advocate's lack of knowledge in the law. They should not ask any advocate to leave the court without sufficient reasons. Similarly, they should not ask any advocate not to come to his court hereafter. Knowing in law. Judges should possess deep knowledge in law. They should have the ability to apply the proper law to the disputed facts and to take the right decision. Independence. Judges have the primary responsibility to protect and preserve the independence of judiciary, hence they should not yield to the pressure of the government. Integrity. A judge should be honest and morally upright. He should have personal and intellectual integrity. His character and conduct should be praiseworthy. Then only the advocates and the general public will have confidence on him. Industriousness. It means regular and systematic hard work and study. A judge should get acquainted with the latest developments and changes in the law by regular updating of the knowledge. Meeting of judges and lawyers. To strengthen bar-bench relation, at regular intervals meeting of judges and the advocates shall be arranged. In such meetings the respective sides' difficulties can be discussed, and the differences can be sorted out. Accountability of lawyers towards court, clients, and society. Accountability of lawyers towards court. Duty to the court, Rule 1-10. In the administration of the justice, the role of the advocate is to help the court to take a right decision in the dispute. While performing this job, an advocate is duty-bound to perform certain duties to the court. Following are duties prescribed by the Bar Council rules as duty to the court, which should be observed by the advocates. An advocate shall show the due respect to the court and shall never act in any manner to undermine the confidence in the judiciary. He shall not exert or attempt to exert any personal influence on the decision of the court, nor shall give any impression that he possesses personal influence with the judge before whom he normally practices. He shall be always punctual in attending courts in the prescribed dress. He shall be fair and frank in the court proceedings. He shall not include any fact which he knows to be false in the pleadings, petitions or affidavits. He shall not ask for any adjournment of a case without genuine reasons. He shall not communicate privately with the judges to influence them relating to any pending case. He shall not speak ill of judges or use abusive remarks about them. But, if the judge behaves improperly, it is not only the right but also his duty to report it to the proper authorities. He shall not interrupt when the counsel for the other side or the judge is speaking. He shall appear in the court in the prescribed dress, and his appearances shall always be presentable. He shall not wear bands or gown in the public places. He shall not practice before a judge if he is related to him. He shall not act or plead in any matter in which he is peculiarly, monetary, interested. He shall not appear for any organization, institution, society, or corporation if he is the member of the executive committee of such organization, institution, society, or corporation. Accountability of lawyers towards clients. Duty to the clients, Rule 11-33. A client is entrusting a case with an advocate because of his trust and confidence on him. In order to honor this trust and confidence, the Bar Council of India Rules 11-33 prescribes the following duties as duty to the client. An advocate is bound to accept a case in the courts or tribunals where he is normally practicing. He shall not withdraw from a case which he has already accepted without sufficient reasons. He shall not withdraw from the case merely because his fees has not been paid in full. He shall withdraw from the case only after giving a reasonable notice to his client. After his withdrawal, he must refund such part of the fees which is in excess in his hand. He shall not accept a case in which he has reason to believe that he will be called as witness. If he already engaged in a case in which he is called as a witness, then he should return the case. But if his retirement will cause irreparable loss to the client, then he can continue to appear as a lawyer. He must make full and frank disclosures to his client relating to his connection with the parties and his interest in the controversy which may likely to affect his client's interest. He should fearlessly uphold the interest of his client by fair and honorable means without the fear of any pleasant consequences to himself or to any other person. He shall not refuse to appear for an accused person merely because in his personal opinion the accused has committed the offense. An advocate appearing as a prosecution counsel shall be fair and shall not conduct the prosecution with hostility to the accused to secure conviction. He should not obstruct the defense counsel in placing the relevant material evidence to prove the innocence of the accused. He shall not disclose any matter communicated to him in his professional capacity to any other person without the consent of his client. He shall not be a party to fomenting or provoking of litigation. He should act at the instructions of his client and not at the instruction of any other person. He shall not stipulate a fee depending on the success of the case or agree to share the proceeds of the litigation. He shall not buy or agree to share the interest of the litigation. He shall not directly or indirectly bid or purchase in his own name or in any other name any property sold in execution of a decree in which he was engaged as a lawyer. He shall not adjust fees payable to him by his client against his own personal liability to the client. He shall not do anything whereby he abuses or takes advantage of the confidence reposed in him by the client. He should keep regular accounts of the client's money entrusted to him. The account should show the particulars of the amount received from the client and the expenses incurred for him. He should maintain separate accounts for the amount received for the fees and for the expenses. The amount received for the expenses shall not be converted for fees without the consent of the client. Where any amount received on behalf of the client, either from the court or from any other person, it should be intimated to the client as early as possible. After the proceedings are over, he shall take the settled fee from the client's money in his hand and the balance, if any, should be returned to the client. If the advocate's fee is left unsettled, he shall take a reasonable fee from the client's money in his hand, after the proceedings are over. A copy of the client's account shall be furnished to him on demand. He shall not convert the client's money in his hand as loan given to him by the client. He shall not lend money to his client for the purpose of any legal proceeding in which he is engaged as the lawyer. but any amount given to his client in an unanticipated emergency shall not be treated as breach of this duty. An advocate who has advised or prepared the pleadings or appeared for a party in any suit or appeal shall not act, appear, or plead for the opposite party. In addition to the above duties prescribed by the Bar Council of India, an advocate is expected to perform the following duties also to the client. He shall give advice to his client honestly and in good faith. He shall prepare the case with due care and skill. He shall submit all relevant documents before the court in support of the claim of his client. He should attend the court on every day fixed for hearing of his client's case. He should return the whole fees received from his client, if he is not in a position to conduct the case. Accountability of lawyers towards society. Justice. An advocate is as an officer of the High Court. He should help the judge in finding out the truth in the dispute and help him to arrive the right decision. For this purpose, he shall submit the proper position of the law, facts, and evidence related to the case. An advocate has to protect the interest of the client, but at the same time he must realize that he is not the mere mouthpiece of the client. Therefore, he shall never resort to unfair practices. His efforts should be always to advance the cause of the justice. Service. Legal profession mainly concerned with the promotion of administration of justice and the establishment of the welfare society. Therefore, lawyers shall be willing to protect the right of the oppressed and the poor. They shall render their service to the general public without any discrimination. Philosophy. Lawyers should have some philosophical outlook. An advocate has to deal with the variety of disputes both favorable and unfavorable to his client. So, he should have the required mental fitness to adjust and accommodate with the changes. It is therefore necessary that lawyers should be guided by some philosophical principles suitable to the profession. Role of law and legal profession in social transformation. Lawyers act as an important service provider to the general public in the capacity of an officer of the court, through their private practice, and by helping people in their different collaborative work. In a democratic society, governed by rule of law, lawyers act as guardians of due process by protecting the rights of the people by demanding due compliance with procedural laws and by enabling access to various legal institutions. The entire notion of fair trial is dependent on the vigilant working of the lawyers, whose demand for procedural and substantive fairness, in the working of legal institutions, goes a long way in protecting the rights of the people, and ensuring rule of law-based society. Lawyers plays a crucial role in promoting equality in society. By representing clients, including clients whose actions are condemned by the society, they fulfill the constitutional goal of equality before law.